The President of India is the head of state and the supreme commander of the Indian Armed Forces. The President is indirectly elected by the people through elected members of both the Houses of Parliament, the Legislative Assemblies of all the states of India and the Legislative Assemblies of the Union Territories of New Delhi and Puducherry, and serves for a renewable term of 5 years. The oath of the President is taken in the presence of the Chief Justice of India and in his/her absence, by the most senior judge of the Supreme Court. Although Article 53 of the Constitution of India states that the President can exercise his powers directly or by subordinate authority, with few exceptions, all of the executive authority vested in the President are, in practice, exercised by the Prime Minister with the help of the Council of Ministers. The President of India resides in an estate known as the Rashtrapati Bhavan, situated in Raisina Hill in New Delhi. The presidential retreat is the retreat in Charabra, Shimla and Rashtrapati Nilayam in Hyderabad. The 13th and current president is Pranab Mukherjee, who was elected on the 22nd of July 2012, and sworn in on the 25th of July 2012. He is also the first Bengali to be elected as president. Origin: India achieved independence from the British on the 15th of August 1947, initially as a dominion within the Commonwealth of Nations with George VI as king, represented in the country by Governor-General. Still, following this, the Constituent Assembly of India, under the leadership of Dr. B.R. Ambedkar, undertook the process of drafting a completely new constitution for the country. The Constitution of India was eventually enacted on the 26th of November 1949 and came into force on the 26th of January 1950, making India a republic. The offices of monarch and Governor-General were replaced by the new office of President of India, with Rajendra Prasad as the first incumbent. The Constitution of the Republic of India gave the President the responsibility and authority to defend and protect the Constitution of India and its rule of law. Invariably, any action taken by the executive or legislature entities of the Constitution shall become law only after President's assent. The President shall not accept any actions of the executive or legislature which are unconstitutional. The President is the foremost, most empowered and prompt defender of the Constitution, who has preemptive power for ensuring constitutionality in the actions of the executive or legislature. The role of the judiciary in upholding the Constitution of India is the second line of defense in nullifying any unconstitutional actions of the executive and legislative entities of the Indian Union. Powers and duties. Duty: the primary duty of the President is to preserve, protect and defend the Constitution and the law of India as made part of his oath. The President is the common head of all independent constitutional entities. All his actions, recommendations and supervisory powers over the executive and legislative entities of India shall be used in accordance to uphold the Constitution. There is no bar on the actions of the President to contest in the court of law. Legislative powers. Legislative power is constitutionally vested by the Parliament of India, of which the President is the head, to facilitate the law-making process for the Constitution. The President summons both the houses of the Parliament and prorogues them. He can dissolve the Lok Sabha. Article 74. The President shall abide by the aid and advice of the Council of Ministers headed by the Prime Minister, provided the given advice is in accordance with the Constitution. Article 143 gave power to the President to consult the Supreme Court about the constitutional validity of any issue. The President inaugurates Parliament by addressing it after the general elections and also at the beginning of the first session each year. This is mentioned in Article 87. The presidential address on these occasions is generally meant to outline the new policies of the government. All bills passed by the Parliament can become laws only after receiving the assent of the President. After a bill is presented to him, the President shall declare either that he assents to the bill, or that he withholds his assent from it. As a third option, he can return a bill to Parliament, if it is not a money bill or a constitutional amendment bill, for reconsideration. When, after reconsideration, the bill is passed and presented to the President, with or without amendments, the President cannot withhold his assent from it. The President can also withhold his assent to a bill when it is initially presented to him, thereby exercising a pocket veto. When either of the two houses of the Parliament of India is not in session, and if the government feels the need for an immediate procedure, the President can promulgate ordinances which have the same force and effect as laws passed by Parliament. These are in the nature of interim or temporary legislation, and their continuance is subject to parliamentary approval. Ordinances remain valid for no more than 6 weeks from the date the Parliament is convened unless approved by it earlier. Under Article 123, President, as the upholder of the Constitution, shall be satisfied that immediate action is mandatory as advised by the Central Cabinet, and he is confident that the government commands majority support in the Parliament needed for the passing of the ordinance into an act, and Parliament can be summoned to deliberate on the passing of the ordinance as soon as possible. The promulgated ordinance is treated as an act of Parliament when in force, and it is the responsibility of the President to withdraw the ordinance as soon as the reasons for promulgation of the ordinance are no longer applicable. Bringing laws in the form of ordinances has become a routine matter by the government and President, but the provisions made in Article 123 amend for mitigating unusual circumstances where immediate action is inevitable when the extant constitutional provisions are inadequate. The President should take moral responsibility when an ordinance elapses automatically or is not approved by the Parliament. The President is liable for prosecution for his wrong deeds. Executive powers. Per Article 53, the executive power of the country is vested in the President and is exercised by President either directly or through offices subordinate to him, in accordance with the Constitution. Union Cabinet, with Prime Minister as its head, should aid and advise the President in performing his functions. Per Article 74, the Council of Ministers or Prime Minister are not accountable legally to the advice tendered to the President, but it is the sole responsibility of the President to ensure compliance with the Constitution in performing his duties. Appointment powers. The President appoints, as Prime Minister, the person most likely to command the support of the majority in the Lok Sabha. The President then appoints the other members of the Council of Ministers, distributing portfolios to them on the advice of the Prime Minister. The Council of Ministers remains in power at the pleasure of the President. The President appoints 12 members of the Rajya Sabha from amongst persons who have special knowledge or practical experience in respect of such matters as literature, science, art and social service. The President is responsible for making a wide variety of appointments. These include governors of states, the Chief Justice, other judges of the Supreme Court and High Courts of India, the Chief Minister of the National Capital Territory of Delhi, the Attorney General, the Controller and Auditor General, the Chief Election Commissioner and other election commissioners, the Chairman and other members of the Union Public Service Commission, Vice-Chancellor of the Central University and academic staff of the Central University through his nominee, ambassadors and high commissioners to other countries. Financial powers. A money bill can be introduced in the Parliament only with the President's recommendation. The President lays the annual financial statement, i. the Union budget. Before the Parliament, the President can take advances out of the Contingency Fund of India to meet unforeseen expenses. The President constitutes a Finance Commission after every 5 years to recommend the distribution of the taxes between the centre and the states. Judicial powers. The President appoints the Chief Justice of the Union Judiciary and other judges on the advice of the Chief Justice. He dismisses the judges if and only if the two houses of the Parliament pass resolutions to that effect by a 2/3 majority of the members present. According to Article 143 of Indian Constitution, if the President considers a question of law or a matter of public importance has arisen, he can ask for the advisory opinion of the Supreme Court. Diplomatic powers. All international treaties and agreements are negotiated and concluded on behalf of the President. However, in practice, such negotiations are usually carried out by the Prime Minister along with his cabinet. Also, such treaties are subject to the approval of the Parliament. The President represents India in international forums and affairs where such a function is chiefly ceremonial. The President may also send and receive diplomats, i.e., the officers from the Indian Foreign Service. The President is the first citizen of the country. Military powers. The President is the Supreme Commander of the Indian Armed Forces. The President can declare war or conclude peace, on the advice of the Union Council of Ministers headed by the Prime Minister. All important treaties and contracts are made in the President's name. He also appoints the chiefs of the service branches of the armed forces. Pardoning powers. As mentioned in Article 72 of the Indian Constitution, the President is empowered with the powers to grant pardons in the following situations. Punishment is for an offence against Union law. Punishment is by a military court. Sentence is that of death. The decisions involving pardoning and other rights by the President are independent of the opinion of the Prime Minister or the Lok Sabha majority. In most cases, however, the President exercises his executive powers on the advice of the Prime Minister and the Cabinet. Emergency powers. The President can declare 3 types of emergencies: national, state and financial, under Articles 352, 356 and AMP 360, in addition to promulgating ordinances under Article 123. National emergency. A national emergency can be declared in the whole of India or a part of its territory for causes of war or armed rebellion or an external aggression. Such an emergency was declared in India in 1962, 1971, and 1975 to 1977. Under Article 352 of the India Constitution, the President can declare such an emergency only on the basis of a written request by the Cabinet Ministers headed by the Prime Minister. Such a proclamation must be approved by the Parliament within 1 month. Such an emergency can be imposed for 6 months. It can be extended by 6 months by repeated parliamentary approval. There is no maximum duration. In such an emergency, fundamental rights of Indian citizens can be suspended. The 6 freedoms under right to freedom are automatically suspended. However, the right to life and personal liberty cannot be suspended. The President can make laws on the 66 subjects of the state list. Also, all money bills are referred to the President for approval. The term of the Lok Sabha can be extended by a period of up to 1 year, but not so as to extend the term of Parliament beyond 6 months after the end of the declared emergency. National emergency has only been proclaimed in India twice till date. It was declared first in 1962 by President Sarvepalli Radhakrishnan during the Sino-Indian War. The second emergency in India was from 1975 75–77 proclaimed by President Fakhruddin Ali Ahmed, with Indira Gandhi as Prime Minister. State emergency if the President is fully satisfied, on the basis of the report of the Governor of the concerned state or from other sources, that the governance in a state cannot be carried out, according to the provisions in the Constitution. He can proclaim under Article 356 a state of emergency in the state. Such an emergency must be approved by the Parliament within a period of 2 months. Under Article 356 of the Indian Constitution, it can be imposed from 6 months to a maximum period of 3 years with repeated parliamentary approval every 6 months. If the emergency needs to be extended for more than 3 years, this can be achieved by a constitutional amendment, as has happened in Punjab and Jammu and Kashmir. During such an emergency, the President can take over the entire work of the executive, and the Governor administers the state in the name of the President. The Legislative Assembly can be dissolved or may remain in suspended animation. The Parliament makes laws on the 66 subjects of the state list. A state emergency can be imposed via the following: by Article 356 if that state failed to run constitutionally, i.e., constitutional machinery has failed; by Article 365 if that state is not working according to the direction of the Union government issued per the provisions of the Constitution. This type of emergency needs the approval of the Parliament within 2 months. It can last up to a maximum of 3 years via extensions after each 6-month period. However, after 1 year it can be extended only if a state of national emergency has been declared in the country or in the particular state. The Election Commission finds it difficult to organize an election in that state. The Sarkaria Commission held that presidents have unconstitutionally misused the provision of Article 356 many times for achieving political motives, by dismissing the state governments although there was no constitutional breakdown in the states. During 2005, President's rule was imposed in Bihar state, misusing Article 356 unconstitutionally to prevent the democratically elected state legislators to form a government after the state elections. There is no provision in the Constitution to re-promulgate President's rule in a state when the earlier promulgation ceased to operate for want of Parliament's approval within 2 months' duration. During 2014 in Andhra Pradesh, President's rule was first imposed on March 1, 2014 and it ceased to operate on April 30, 2014. President's rule was promulgated after being fully aware that the earliest Parliament session is feasible in the end of May 2014 after the general elections. It was reimposed again unconstitutionally on April 28, 2014 by the President. Financial emergency. Article 282 accords financial autonomy in spending the financial resources available with the states for public purpose. Article 293 gives liberty to states to borrow without any limit to its ability for its requirements within the territory of India without any consent from the Union government. However, Union government can insist for compliance of its loan terms when a state has outstanding loan charged to the Consolidated Fund of India or an outstanding loan in respect of which a guarantee has been given by the Government of India under the liability of Consolidated Fund of India. Under Article 360 of the Constitution, President can proclaim a financial emergency when the financial stability or credit of the nation or of any part of its territory is threatened. However, until now no guidelines defining the situation of financial emergency in the entire country or a state or a union territory or a panchayat or a municipality or a corporation have been framed either by the Finance Commission or by the central government. Such an emergency must be approved by the Parliament within 2 months by simple majority. It has never been declared. A state of financial emergency remains in force indefinitely until revoked by the President. The President can reduce the salaries of all government officials, including judges of the Supreme Court and High Courts, in cases of a financial emergency. All money bills passed by the state legislatures are submitted to the President for approval. He can direct the state to observe certain principles relating to financial matters. Selection process. Eligibility. Article 58 of the Constitution sets the principal qualifications one must meet to be eligible to the office of the President. A President must be a citizen of India, of 35 years of age or above, qualified to become a member of the Lok Sabha. A person shall not be eligible for election as President if he holds any office of profit under the Government of India or the government of any state or under any local or other authority subject to the control of any of the said governments. Certain office holders, however, are permitted to stand as presidential candidates. These are the current Vice President, the Governor of any state, a Minister of the Union or of any state. In the event that the Vice President, a state governor or a minister is elected President, they are considered to have vacated the previous office on the date they begin serving as President. Under the Presidential and Vice Presidential Elections Act, 1952, a candidate to be nominated for the office of President needs 50 electors as proposers and 50 electors as seconders for his name to appear on ballot. Conditions for the presidency. Certain conditions, per Article 59 of the Constitution, to bar an otherwise eligible citizen from contesting the presidential elections. The conditions are: the President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President. The President shall not hold any other office of profit. The President shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and until provision in that behalf is so made. Such emoluments, allowances and privileges as are specified in the second schedule. The emoluments and allowances of the President shall not be diminished during his term of office. Election process. Whenever the office becomes vacant, the new president is chosen by an electoral college consisting of the elected members of both houses of parliament, the elected members of the state legislative assemblies of all states and the elected members of the legislative assemblies of 2 union territories of Delhi and Union Territory of Puducherry. The election process of president is more extensive process than prime minister, who is also elected indirectly by the Lok Sabha members only, whereas president being constitutional head with duties to protect, defend and preserve the constitution and rule of law in a constitutional democracy with constitutional supremacy, is elected in an extensive manner by the members of Lok Sabha, Rajya Sabha and state legislative assemblies in a secret ballot procedure. The nomination of a candidate for election to the office of the President must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Each candidate has to make a security deposit of 15,000 rupees in the Reserve Bank of India. The security deposit is liable to be forfeited in case the candidate fails to secure 1/6 of the votes polled. The election is held in accordance to the system of proportional representation by means of the single transferable vote method. The voting takes place by secret ballot system. The manner of election of President is provided by Article 55 of the Constitution. Each elector casts a different number of votes. The general principle is that the total number of votes cast by members of Parliament equals the total number of votes cast by state legislators. Also, legislators from larger states cast more votes than those from smaller states. Finally, the number of legislators in a state matters. If a state has few legislators, then each legislator has more votes. If a state has many legislators, then each legislator has fewer votes. The actual calculation for votes cast by a particular state is calculated by dividing the state's population by 1,000, which is divided again by the number of legislators from the state voting in the Electoral College. This number is the number of votes per legislator in a given state. Every elected member of the Parliament enjoys the same number of votes, which may be obtained by dividing the total number of votes assigned to the members of Legislative Assemblies by the total number of elected representatives of the Parliament. Although Indian presidential elections involve actual voting by MPs and MLAs, they tend to vote for the candidates supported by the respective parties. Oath or affirmation. The President is required to make and subscribe in the presence of the Chief Justice of India an oath or affirmation that she shall protect, preserve and defend the Constitution as follows. I swear in the name of God that I will faithfully execute the office of President of the Republic of India, and will to the best of my ability preserve, protect and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of the Republic of India. Emoluments. The President of India used to receive 10,000 rupees per month per the second schedule of the Constitution. This amount was increased to 50,000 rupees in 1998. On the 11th of September 2008, the Government of India increased the salary of the President to 1.5 lakh rupees. However, almost everything that the President does or wants to do is taken care of by the annual 225 million rupees budget that the government allots for his or her upkeep. Rashtrapati Bhavan, the President's official residence, is the largest presidential palace in the world. The Rashtrapati Nilayam at Ballaram, Hyderabad and Retreat Building at Charabra, Shimla are the official retreat residences of the President of India. The official state car of the President is a custom-built heavily armoured Mercedes-Benz S600 Pullman Guard. Presidential amenities.